Good morning, everyone. I'm Alicia Krause, live from PragerU HQ here in Los Angeles. And on the East Coast today, we are joined by a very special guest and a numerous time PragerU presenter, Alan Dershowitz. Alan, good morning, and thank you for being with us today.
Hi.
Appreciate you being here. So there have been a lot of decisions this week and a lot of things happening on Capitol Hill that people are talking about. And I'd love to get into your legal mind. Specifically, Ryan Anderson over at the Heritage Foundation has said that it's been a good week for religious liberty at the Supreme Court. He's referencing the decision of the state of Missouri versus the Christian school there. And of course, the Supreme Court is going to be also reviewing a case in a baker that was told and then fined for not baking a gay wedding cake.
Let me get to that one first. That is the dumbest case ever. It is not about religious liberty. If a baker wants to exercise religious liberty, they ought to stop selling cakes to Christians who have been divorced and want to be remarried. That's right in the New Testament. It says, if you've been divorced, you cannot be remarried. How dare any cake baker say that it's okay to sell my cake to a divorced person, but it's not okay to sell it to a gay person who's getting married? There's nothing in the New Testament about gays getting married. This is the worst form of hypocrisy. It is homophobic bigotry disguised under the pretense of religious liberty. And it's no different than as if an Afro-American person and a white person wanted to get married and a cake baker said, I'm not baking a cake for them because my interpretation of the Bible is that a black person can't marry a white person. It is a phony argument. The Supreme Court should have just thrown it out immediately. It hurts religious liberty because it uses religious liberty as a pretext for utter and absolute bigotry.
So then you're okay with states and lower courts fining people for refusing service to anyone?
Well, if there is a genuine religious basis, that would be one thing. I mean, I think it would be a hard case if a person said, I will not bake a cake for somebody who is divorced. The New Testament says divorce is an impermissible basis for a remarriage. But if they bake cakes for divorced couples who won't bake it for gay couples, that's not religious.
So you're okay with the court determining then someone's perspective or their view of what the Bible says about a specific topic then?
I'm okay when it's a totally phony argument. This argument is as phony as if it were a black and white person. Let me throw the question back at you. Do you think the court would take the case if a baker refused to bake for a black and a white person, or a hotel refused to accept patronage from a couple, one of whom was black and one of whom was white?
I think that they should.
Simply no difference between that and a gay couple, but there is a difference between a divorced couple. You know, when hotels start checking and seeing, oh, you've been divorced and now you're remarried? No, that's not a legitimate marriage. We don't accept unmarried couples in our hotels. It's the phoniest argument. We have to understand from a common sense point of view the difference between religious practice and utter and complete homophobic bigotry.
But I guess my follow-up would be, is it the responsibility of any circuit court or any justices, sitting on the Supreme Court to then be able to dictate and determine how someone views the biblical teaching?
Well, no, you don't do that. You just look to see if there's hypocrisy. If they're really doing it on the basis of the Bible, their views have to be authentic and genuine, and they have to be religious. And I think refusing to bake a cake for a gay couple is simply a reflection of utter and complete bigotry. There's no possible religious justification for that if you're prepared to bake a cake for a person who was divorced and remarrying. I challenge any Christian to come forward and show me a religious justification for that.
Okay, moving on. Another, what some people have said is a win for religious liberty, is this decision in the Supreme Court to review the case of this Missouri school. Or actually, I believe they struck down because they said that Missouri violated the Constitution's free exercise clause. What are your thoughts on that?
Well, it's a close question. That's a hard question. How much the state can support non-religious aspects of religious schools is a hard question. On the one hand, every penny it gives to a religious school to build a playground is a penny the religious school can then use to teach religion. That's an argument against allowing it. On the other hand, people go to school, they're compelled to go to school, they ought to have safe playgrounds. So the state ought to be able to give money to help build safe playgrounds. I predict the court's going to come out in favor of allowing the expenditure of money for playground areas. But I don't think they're going to come out in favor of the gay baker, the baker who won't provide a cake for gay marriage.
And the final case is the Supreme Court, partially unblocked parts of President Trump's recent travel ban, his executive order, of course. Some people are saying that this is a good thing. Some people, three of the justices said that they didn't think that the travel ban went far enough or the decision went far enough. Your thoughts?
Well, I think the Supreme Court in the end is going to decide this case not on the basis of what, but on the basis of who. Who has the right to challenge this order? And I think the court will hold, and I think Chief Justice Roberts, will write the decision because he is the expert on standing, will say that a family from Yemen who's never been to the United States and has no connections to the United States has no standing to challenge the order, but that people who have close connections to the United States do have standing, and then the court will have to reach the issue of whether or not the ban based on six Muslim-majority countries, selected, of course, by the Obama administration initially, is constitutional or unconstitutional. I think in the end, careful analysis will uphold most of the ban, but might strike down on due process grounds some of the ban. The problem is not going to be the Constitution. It may be the statute. There's a statute that prohibits discrimination based on national origin, and the court may focus on that statute, but Congress could overrule that if they choose to.
Okay. So if everyone wants to stay tuned after this PragerU Live, we will be streaming all of Alan's videos that he has done for PragerU. In addition to that, we'll be streaming a video that talks about the Supreme Court and the decisions that they've made in the past, why we're losing liberty. It was presented by Robert George, so stay tuned for that. Alan, I'd love to get your thoughts on, now we've heard there's a couple of FBI investigations that have been in the news this week. Of course, people over at CNN resigned over a Russia investigation story where they had an anonymous source that was then totally debunked and has led into the hashtag fake news narrative. In addition to that, we now know that Carter Page during the campaign was interviewed by the FBI. Some people are for Mueller in continuing the investigation. Others feel like he shouldn't be trusted. What are your overall viewpoints, and where do you think this is going to end up?
Well, I think there should have been an independent commission, much like the 9/11 Commission, established by Congress, bipartisan, nonpartisan, looking into the entire issue of Russia involving itself in American elections. It ought to be looking forward, not backward. It ought to be thinking about passing new laws, making American complicity in that a crime. But an FBI investigation is the wrong place to go because I don't think any crimes were committed. It wouldn't have been a crime, hypothetically. This didn't happen. But hypothetically, if Donald Trump, running for president, called Vladimir Putin and said, I really appreciate if you could help me become president, and if you do, by lawful means, I will stop the sanctions. That would be wrong. It would, of course, resulted in him not being elected. But I can't find any criminal statute that would have violated. So I don't think an FBI investigation is the right way to go. It's also behind closed doors. It's a grand jury. We'll never know what really was found out. An open public inquiry would have been a far better way of addressing the very serious problem of Russia being involved in any American or any foreign election.
It would have been more transparent for sure. Do you think that the President Obama or the Obama administration is culpable in any way of the alleged hacking that occurred between Russia and the United States, considering he apparently knew last summer?
I'm very surprised that that didn't come out, particularly when Comey announced that there was an investigation of Hillary Clinton's emails. It surprises me that it wasn't leaked somehow, that there was also an investigation of possible collaboration between people on the Trump team and the Russians. But selective leaks have that problem. They're leaked selectively for political purposes, and it's wrong. And I think that Comey really disgraced himself when he leaked material through a law professor at Columbia instead of having the courage to stand in front of the camera and say, I want there to be a special counsel, and I'm going to tell you what the president said to me and how he said it. He didn't do that. He leaked it. The head of the FBI, whose job it is to prevent leaks, should not be leaking.
Do you think that he should be charged for those leaks?
I don't think it's crime. There was no national security issue. There was no grand jury issue. It was just wrong. We have to make sure that we always distinguish between what we don't approve of and what is criminal. There's a great deal that both the Obama administration and the Trump administration have done that I think is wrong. But I have to know what the criminal statute is and why you think there's evidence beyond a reasonable doubt that somebody violated that statute. I think we conflate sin and crime. political sin and crime in this country far too much. We're doing it now with Sanders, Jill Sanders, and Bernie Sanders. We're investigating them for something that sounds like it's civil rather than criminal. Both sides use the criminal justice system as weapons in their hyper-partisan attacks on their opponents, and civil liberty suffers when that happens.
You mentioned Bernie and Jill Sanders, of course. This has been a Twitter upheaval, and some in the media are talking about it, but others aren't. Some people are comparing the media coverage to when Marco Rubio's wife was discovered to have multiple speeding tickets, that got way more news from the mainstream media than this story of Jill Sanders being investigated by the FBI for what you just said is more of a civil issue. You wrote a piece today for FoxNews.com in which you say that you think that the Sanders FBI bank loan investigation is dangerous territory. Can you explain that?
Yeah, I think it's part of the same issue of the Trump investigation. People should not be using the criminal justice system to make political attacks on their enemies. I said that when Nixon was named as an unindicted co-conspirator. I said it when Clinton was subject to impeachment. I said it when Tom DeLay, when Rick Perry, when Senator Stevens, when Bob Menendez. All of these are political attempts to use the criminal justice system to criminalize political differences, and they're wrong, whether it's done by Republicans against Democrats or Democrats against Republicans. The Republican National Committee is now having a ball, sending out tweets and messages about how terrible Sanders is and he ought to be prosecuted. The Democrats are doing the same thing with Trump. Neither should be doing it.
So even though it's the independent or the allegedly independent FBI looking into this, we don't have any proof that it was spurred on by a Republican senator to look into Jill Sanders. You still think that these are being used as political games?
Oh, no, we do have proof. We have proof it was done by the chairman of the Trump campaign in Vermont. And in my article, I name him and I quote what he said. And no question, it was stimulated by a Republican operative. And that's why my civil liberties antenna goes up. Whenever a political operative commences a criminal investigation against a political opponent, I have to look very hard to see whether there is a justified basis for it. Now, I don't see any justified basis either in the Trump or the Sanders investigations.
So final question for you, sir. I'd love to know your legal thoughts and maybe even political opinion. When Comey did testify, one of the tidbits, of course, that people on the right grabbed onto is that he had been asked by then Attorney General Loretta Lynch to refer to the Hillary Clinton FBI investigation as a matter when he appeared before Congress.
That was wrong. It shouldn't have been done. But again, it's not a crime. It's just wrong. And we should be critical of that. The Attorney General not to be using political talking points in talking to the FBI director and telling him how to categorize a case. Look, it shouldn't have been referred to at all. That's the big mistake. Nobody should have known about this. The FBI, like the classic child, should be seen but not heard. We shouldn't have heard from the FBI director until a decision was made to indict or not to indict. That's equally true of the Hillary Clinton matter and of the Russian probe. But of course, selective leaking brought one of them to the attention of the public and not the other one.
Alan, thank you so much for your time today. We really appreciate it, and thanks for being a member of the PragerU family. I'm Alicia Krause from the PragerU HQ, reminding you that our PragerU videos are able to be kept free because of generous donations from people like you. So you can click on the link in this Facebook Live and make sure to donate. Even $5 makes a big difference. Heck, I spent $8 on coffee for Noah and I, our tech guy, this morning. So $8 goes a long way to make sure that millennials like myself, people that are 35 and under, are impacted by the importance of our videos. We'll be streaming some of those starting right now, including about a video specifically talking about past decisions of the Supreme Court and all of Alan Dershowitz's videos that he's done here for us at PragerU. Thanks so much, everyone. Be sure to tune in tomorrow because we have a new presenter and an in-person sit-down PragerU Live, just special for our audience. Thanks.
How did the framers of the Constitution of the United States seek to preserve liberty and prevent tyranny? Pretty basic question. Here's the answer I usually get from my students. Well, Professor, to protect the individual and minorities against the tyranny of the majority, they added the Bill of Rights, and they gave the power to enforce those rights to the Supreme Court. Are my students correct? The editorial boards of the New York Times or the Washington Post and many members of the U.S. Congress would say yes. Unfortunately, the answer is wrong. I say unfortunately because it reflects a common misunderstanding of the Constitution, and that misunderstanding has led to a serious erosion of our freedom. Let me explain. Both the Bill of Rights and judicial review, the idea that the courts can decide if a law is constitutional or not, were hotly debated items when the Constitution was being drafted in 1789. The Federalists, the group led by Alexander Hamilton that wanted a national constitution, opposed including a Bill of Rights. They feared it would actually undermine what the Federalists regarded as the main protections against tyranny in the document, the limited nature of the national government itself. The Constitution did not envision a national government of general jurisdiction, meaning a government that could do whatever it wanted, but rather a government of enumerated and delegated powers, a government that had authority over only specific areas of American life. All other powers were to be beyond the scope of the national government and reserved to the states or to the American people themselves. That's why when political necessity forced the Federalists to yield to demands for a Bill of Rights, they took care to add two important amendments, the 9th and 10th. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. These amendments reinforce the idea that the national government couldn't just assume powers it had not been specifically granted by the Constitution. Unfortunately, these amendments have not stymied the expansion of the national authority. The power grab the Federalists feared, the national government taking more and more control over more and more areas of American life, took place. Not immediately, but over time, and especially beginning in the second half of the 20th century. That same time frame has seen a similar concentration of power in the judiciary, especially in the Supreme Court, so that now most Americans think of the Supreme Court as the ultimate arbiter of almost every social and political dispute. The founders never envisioned the court in this role. How has the court fared in playing it? Well, there have been moments of glory, to be sure, such as in the racial desegregation case of Brown against the Board of Education in the 1950s. But it has also handed down decision after decision, from Dred Scott against Sanford in the 1850s, which facilitated the expansion of slavery, to Roe against Wade in the 1970s, which legalized abortion throughout the United States, in which the justices have plainly overstepped the bounds of their authority by creating law from the bench, thereby further expanding their own power and that of the national government. Moreover, the Supreme Court has done little to stop the executive and legislative branches of the national government from unconstitutionally overreaching. Recently, the court found a way, by a bare majority, to uphold an obvious case of constitutional overreach by the national government, the imposition of a law, or individual mandate as it is known, requiring every citizen to purchase health insurance coverage as part of President Obama's signature Affordable Care Act. The government defended this mandate as a legitimate exercise of its expressly delegated power to regulate commerce among the states. The trouble is that the mandate does not regulate commerce at all. Rather, it forces people into commerce on pain of a financial penalty. But why did the issue get to the courts at all? Congress and the president should have recognized and honored the fact that the Constitution simply does not empower the national government to impose a mandate on the people to purchase products, whether health insurance or anything else. We've drifted a long way from the original vision of the founders. The further we've drifted, the more powerful the national government has grown, and the less free Americans have become. Freedom can be taken away, but it can also be given away out of sheer ignorance. If we Americans, we the people, want to get some of that freedom back, we need to read America's founding documents. All the freedom we ever wanted is there. I'm Robert George, professor of jurisprudence at Princeton University, for Prager University.
Is Israel's policy of building civilian communities in the area known as the West Bank the reason there is no permanent peace between Israel and the Palestinians? The answer to that question, despite all the sound and fury regarding the so-called settlement issue, is no. The Israeli settlements in the West Bank are not the major barrier to a peace agreement. A little historical context will make this clear. For 2 decades, before June of 1967, the West Bank, including much of Jerusalem, was controlled by Jordan. During that time, a time when Israel did not have a single settlement, there were numerous Palestinian terror attacks against the nation-state of the Jewish people. In other words, Palestinians committed terror attacks against Israel when there were no settlements. And they committed terror attacks against Israel when there were settlements. If Israel were to pull out of every single settlement in the West Bank tomorrow, it's unlikely that anything much would change. In fact, if history is any indicator, Israel could be worse off. In 2005, Israel abandoned every single community, every house, every farm, every structure it had built in the Gaza Strip. How did the Palestinians of Gaza react? They launched thousands of rockets and numerous other terror attacks against the nation-state of the Jewish people. The attacks continue to this very day. And every year, the range of these rockets get longer and their payloads more lethal. Only a very sophisticated Israeli anti-missile defense keeps the country secure. Can you blame Israel for not wanting to risk a two-front rocket war? But Israel has no right to be in the West Bank at all, many say. So permit me, a law professor at Harvard, to say that on the basis of international law, this position is incorrect. Military occupations are clearly permitted under international law following an aggressive attack by a neighboring state. Jordan, Israel's neighbor to the east, attacked Israel in 1967, despite Israel's repeated efforts to keep Jordan out of the Six-Day War. In defending itself against Jordan, Israel captured the West Bank and the eastern part of Jerusalem. Under international law, until a meaningful peace is achieved and all terrorism against it ceases, Israel has every right to retain military control over this area. Since no peace treaty has been reached and the terrorism continues with new attacks threatened almost daily, Israel is under no legal obligation to leave. Given the danger that Israel would be putting itself in if it did leave the West Bank, exposing its major cities and international airport to rocket attacks, it would be irresponsible to do so, which is why Israel is still there. Nevertheless, I fully acknowledge that a military occupation is significantly different, both as a matter of law and politics, from building civilian settlements, even in a territory that is legitimately subject to a military occupation. That's why I have long opposed the building of settlements in the West Bank. I believe it has caused resentment and has given enemies of Israel an excuse to attack the legitimacy of the occupation in general. It is also why I have always supported Israel's efforts to exchange land for peace, as it has done on multiple occasions over the last few decades. So while the settlements may have contributed to the difficulty of making peace, it has not been the major barrier that Israel's enemies claim it to be. It is not the reason there has been no peace agreement between Israel and the Palestinians. The reason has always been and remains the unwillingness of Palestinian leaders, and according to Palestinian polls, much of the Palestinian population, to recognize Israel's right to exist as the nation-state of the Jewish people. Until and unless the Palestinian leadership and the Palestinian people acknowledge that the state of Israel has the right to be free from military assault, from terrorism, from rocket attacks, and from diplomatic warfare, there will be no resolution to the Middle East dispute. If these conditions, which must be the basis of any two-state solution, meaning a nation-state for the Jewish people and a Palestinian state, are met, the occupation will end, the settlement issue will be resolved, and the blessings of a mutual peace will finally be achieved. I'm Alan Dershowitz, professor of law at Harvard University for PragerU University. Of all the countries that have come into existence in the last century, no country's birth certificate is more legitimate than that of Israel. One reason is that many of the men who founded the country, Theodor Herzl, Zeb Jabotinsky, David Ben-Gurion, Menachem Begin, Yitzhak Shamir, were either lawyers or had legal training. They were obsessed with making it legal. Unlike almost every other country, lawyers, not generals, were the midwives of Israel's birth, or more accurately, rebirth, since it had existed as an independent country twice before in history. Step by legal step, Israel moved legally toward nationhood, from the Balfour Declaration in 1917 to the San Remo Agreement in 1920, to the League of Nations Resolution in 1922, to the Anglo-American Convention on Palestine in 1924, to the partition of land ordained by the United Nations in 1947 into a nation-state for the Jewish people and an Arab state. Yet immediately upon its lawful establishment in 1948 as the nation-state of the Jewish people, Israel was illegally attacked by all the surrounding Arab states, as well as by elements of the local Arab population. In defending its right to exist during that war, Israel lost 1% of its population, including many civilians and Holocaust survivors. It also lost some of the land assigned to it by the United Nations. It captured other land from the aggressors that was originally assigned to the Arab state. The end result of that war against Israel was an armistice line that prevailed until 1967, when Israel was once again attacked by Jordan during Israel's war with Egypt and Syria. Between 1948 and 1967, despite the armistice, Arab terrorists continued to infiltrate Israeli borders and to injure and kill Israeli citizens. That was part of an official policy by the surrounding governments and by leaders of local Palestinian groups. All of it was in violation, obvious violation of international law. Following the establishment of Israel, a transfer of populations occurred. Several 100,000 Arabs who fled from Israel during the War of Independence were not allowed to return. Some had chosen to leave, assured by their Arab leaders that the fledgling country would not last a week. Others were forced to leave. At that time, approximately the same number of Jews were forced to leave Arab countries, another violation of international law, where they had lived for thousands of years. The difference was that Arab countries kept the Arabs who left Israel in refugee camps, where many of them still live more than half a century after leaving Israel. And Israel, on the other hand, fully integrated all the Jewish refugees from Arab countries into Israeli society, where many of their descendants now serve in the highest positions of Israeli life. Israel's establishment as the nation-state of the Jewish people by entirely lawful means is quite remarkable for several reasons. First, there is no country in the world that is as surrounded by hostile enemies as is Israel. It's been that way since 1948. Yet Israel sought the way of the pen rather than of the sword. It has needed the sword to survive, but its preference has always been for the pen. That is, for peaceful negotiations. Its peace treaty with Egypt in 1978, its peaceful abandonment of Gaza in 2005, and its many attempts to reach a peace agreement with the Palestinians are examples. Yet despite its entirely lawful origins, Israel is the only country in the world today whose origins, and therefore its very legitimacy, have been questioned by the General Assembly of the United Nations, by numerous member nations, and by many organizations that claim the mantle of human rights and the rule of law. Ironically, current attacks on Israel's legitimacy have taken the form of lawfare, the use of international law as a weapon. Any fair tribunal that judged Israel by universal standards would reject such attacks out of hand. But alas, international courts like the UN itself have been packed by those bitterly antagonistic to the nation-state of the Jewish people. For example, the misnamed International Court of Justice refuses to acknowledge that Israel, a country that deals with terror attacks and the threats of terror attacks on a regular basis, has any special security needs. As I've demonstrated, this phenomenon, questioning the very right of Israel to exist as the nation-state of the Jewish people, cannot be explained on legal grounds or on any other rational basis for that matter. So then, how can this worldwide attack on Israel alone be explained? In only one way. It is pure bigotry. And there's a word for this bigotry: anti-Semitism. If you have a better explanation for why the one country in the world whose right to exist is denied is also the one country that is the nation-state of the Jewish people, I ask you, what is it? I'm Alan Dershowitz, professor of law at Harvard University for PragerU University.